you can be held capable of doing something because you are of a particular age or because you are not of a particular age, and you have been found guilty of a particular offense, be it murder, rape, defilement, indecent assault, stealing, and all of those offenses, the law says that you cannot be sentenced to prison. Number two, you can only be sent to prison for maximum of 3 years, no matter the category of offense you've committed. You can actually enter into a marriage without the written consent of your parents. In this video, I explained to you 7 unique ages under the law and their legal implications. Be sure to watch this video till the end and understand what the implications are if you belong to any of these age categories. I am Godwin Selassie Dakbo, and this is Make It Legal.
Make it legal.
The law oftentimes gives people the ability to do things or hold them accountable for being able to do certain things based on their age. In other words, you can be held capable of doing something because you are of a particular age or because you are not of a particular age. So there are indeed certain age categories that are very unique to the law. And in this video, we are going to explain 7 of those to you. And without wasting much time, let me take the very first one. Now, the first one is people below the age of 5. Now, if you are below the age of 5, the law has a special place for you within the matters of law and all issues concerning legality. The law says that, first of all, you should be called an infant. That is how the law describes you. And there are certain offenses, or there is a particular offense that can be committed against you because you are an infant. Now, we'll take a look at that offense in a jiffy. So that offense simply contemplates that as a child, your needs are taken care of. As someone who is an infant, society takes care of you, relatives and parents take good care of you and maintain you. The law imposes an obligation on them to ensure that they don't at any point in time abandon you or leave you at a place. So Section 96 of the Criminal and Other Offences Act 1960, which we simply call Act 29, clearly creates an offense for anyone who abandons you or leaves you at a place, either a hospital or home or place of residence, without you being maintained. And that is the offense we call child abandonment or an abandonment of infant. Now, let me read for you the exact section. Section 96 of Act 29 says that a person who is bound by law or by virtue of an agreement or employment to keep charge of or to maintain a child under 5 years of age, or who is unlawfully in possession of a child, abandons the child by leaving it at a hospital or at the house of any other person or in any other manner, commits a misdemeanor. So if you are the one who is responsible under law, maybe a parent or relative, or one whose custody a child is placed, that is an infant in this case, someone who is less than 5 years, not that you are by law required to, or maybe you are by an agreement required to do, you have been employed or so to do it. If you fall under these 3 categories, you are expected by the law to ensure that that infant is not left unattended to, it's not left unmaintained, or you are always able to be there for the child and maintain that infant. So this is a very unique age that parents and everyone supposed to know about, because knowing about this age helps you to treat this category of persons with extra care. The law says that don't abandon them anywhere, don't leave them at a hospital without maintaining them, and don't neglect to take good care of them. If you do so, you'll be guilty of child abandonment and you'll be sentenced to prison for at most 3 years. What is the second age group that you need to know about? The second age group is people who are 12 years old. Now, in law, once you are born from day 1 to 11 years, if you commit any activity which is criminal in nature, you will not be held liable for it because you are not yet 12 years. But immediately you turn 12 years old, any act you engage in which is criminal in nature, you will be held responsible for the consequence that flows in law for that action. In other words, you'll be punished for committing any criminal offense once you are 12 years old. So if your child is 12 years old and he engages in any criminal activity, maybe stealing or murder or rape or defilement and things like that, the child will be held liable for it. I mean, probably you are just asking me if the child can engage in rape when he's 12 years old. If he ever forces someone and have sex with a person without a person's consent and he's 12 years old, he will be liable for punishment for rape. But I will explain a little more to you about how they are punished in subsequent age categories. So we've learned so far the first age is people under the age of 5 and they are regarded as infants. And the second category of persons whose age is unique to the law is persons who are 12 years old. The third category is persons who are 16 years of age. If you are 16 years of age, the law has a lot of implications for being at that age. The first one is that if someone sleeps with you or have sexual intercourse with you without your consent, the person will be guilty for criminal rape or rape, and that person can go to prison for 25 years maximum. Now, what it means is that once you are 16 years, most often than not, females who are 16 years and engage in sexual intercourse, and that sexual intercourse is not with their consent, whoever is the party that forces them to enter into that sexual relationship or that sexual intercourse will be guilty of rape and will go to prison. That is the first implication. Once you are 16 years, you have that special protection of the law that if anybody wants to have sex with you, the person must get your consent. And that consent must be throughout the entire sexual activity. If at the beginning you consented to it and you guys begin to engage in the sexual activity, then along the way you ask the person to stop, he's supposed to stop because you have withdrawn consent. If the person doesn't stop, the law will say that he has engaged in sexual activity with you, consensually, but along the way it was not consensual. Therefore, he can be punished for rape. That is my view, because the law is clear that consent must be clearly given and it must be given for the entire duration of the activity. So, that's something you need to know. If you are a female child especially and you are 16 years old, just know that nobody has a right to engage in sexual intercourse with you unless they have your full, clear, precise consent to do so. That is a unique age and you want to respect the privileges that come with it under the law. The fourth category is the age of 18 years. Now, when you are 18 years of age, the law gives you a special recognition. You can be fully responsible for a number of things, both criminally and civilly. You can be responsible, or you may have the capacity to do a number of things just because you are 18 years. The first one is that you are able to get married, but with the consent of your parent or a relative or persons who are playing parental roles in your life. So at the age of 18, either you are male or female, you can actually get married with the consent of your parent. The next implication of being 18 years is that you have the capacity under the law to make your own will, transferring your own properties to someone else upon death. In other words, you can make a will once you are 18 years old. So if you are 18 years, either you have a car, you have a land, you have a house, any kind of property you have at all, just know that you are capable of making a will to dispose of those properties when you die. So that when you die, when you're 19, 20, 90 years, 60 years, 70 years, or 80 years at all, the will you make when you are 18 years will still have effect of law. Just because being 18 years gives you legal capacity to make a will. The fifth category is persons between the age of 12 and 18 years. So once you are between 12 and 18 years, the law again gives you a special recognition. Now, in law, if you are subject to some sort of criminal activity, the law calls you a juvenile. That is the name they give you. Even though you are still a child, the law calls you a juvenile. And there are special provisions for how you'll be treated when you commit a crime. Number one, if you are within this age bracket, 12 to 18, and you have been found guilty of a particular offense, either it is a minor offense or a serious offense, be it murder, rape, defilement, indecent assault, stealing, and all of those offenses, the law says that you cannot be sentenced to prison with the adults. That is the first thing. You cannot be sent to a normal prison. You cannot be sent to prison at Nsawam or a normal prison that every other adult offender is kept. You cannot be kept there at all. Under no circumstance should you, who is 12 years, 13 years, 14 years, all the way to 17 years, be kept with an adult offenders or be kept in a normal prison. Where then would you be kept? Now, if you are found guilty of a crime and you are sentenced to prison, your prison is called Junior Correctional Center. That is where you'll be kept as a child who has committed an offense. You are not supposed to be sent to prison. What it means is that if for some reasons you have been guilty of a crime and you have been placed right now in prison, or you have been placed in prison before when you were 18 years, when you were 17 years, I mean, people who did that actually violated your right. You are not supposed to be sent to normal prison. You were supposed to be kept at a junior correctional center. Another implication is that you cannot be sent to prison beyond 3 years. Even at the junior correctional center, you cannot be kept there more than 3 years. The maximum years you can be in prison as a child who is between the ages of 12 and 18 is 3 years maximum. That is the maximum you can stay. In other words, whether you commit murder, you commit rape, defilement, no matter the offense you commit, you can only be sentenced to prison for 3 maximum years, just because you are between the ages of 12 to 18. So just to summarize it again, those who are between 12 to 18 years, there are 3 legal implications for you. Number 1, you cannot be kept in the same normal prison with any other offender who is an adult offender. Number 2, you can only be sent to prison for a maximum of 3 years, no matter the category of offense you've committed. The third and not the least is that your prison is not the normal prison everyone goes. It's called the Junior Correctional Center. The 6th age category is the age of 21. Once you are 21 years, you have special recognition by the law. The law gives one important legal implication to you. That is, you can actually enter into a marriage without the written consent of your parents or relative or persons who are taking care of you. Now, this, of course, is what the law says, that you don't need the consent of your parent or relative before you can marry when you are 21 years. The law wouldn't expect you to produce a written consent before you can marry when you are 21 years. However, these laws oftentimes are implemented within our cultural values and societal beliefs. So sometimes for the peace of the home, you go ahead and require the consent of both parents. A lot of times the religious rules come to play, and those rules expect you to obtain the consent of both parents, whether you are above 21 years or not. But technically speaking, what the law says is that once you are 21 years of age, you are not required to produce a written consent of your parent, a relative, before you can be given a license to go and celebrate an ordinance marriage or marriage. This is strictly in terms of what the law expects in ordinance marriage. The rules are different when it comes to customary rules. Those rules will often expect you to, as of necessity or mandatory requirement, obtain the consent of your parent before you can marry. But as far as ordinance is concerned, the law does not expect it of you. But you can go ahead and still obtain that consent, not a written one per se, but approval of the parent to engage in marriage if you are 21 years. The last but not the least, certainly, is persons between the age of 18 and 21. The law calls you young offenders. When you commit an offense in this category, the law treats you as a young offender. You are not a juvenile, so to say, but you are a young offender and you have special treatment. Number 1 is that you cannot be kept in the same prison with adult offenders, persons who are beyond 21 years or who are 21 years and above. But you will also be kept as a place the law calls senior correctional centers. They are also the prison meant for young offenders. I believe you enjoyed this video. You want to click on the like button to like it, and please don't forget to subscribe to the channel, subscribe to Make It Legal channel, and do share our videos across to all your colleagues. Let them know about what we share here. And I believe this education can be empowering and can make you aware of what the law says about many things, especially special ages under the law. I am Godwin Selassie Dakpo, and this is Make It Legal.
Make it legal.